120 WPM English shorthand dictation. Be ready for it. Start. Para. Commission of present crime. Full stop. In the instant case, the prosecution had tried to prove the charges framed against the appellants on the basis of evidence of PW1 to PW4. Full stop. Prosecution also relied upon the statement of PW6 that from the possession of the appellants some stolen articles recovered. Para. We have considered the prosecution evidence and find that the prosecution tried to prove the recovery of stolen articles only on the basis of deposition of PW6, the investigating officer. Full stop. This witness stated that three ducats were arrested simultaneously from one place. Full stop. He further deposed that all three articles seized because they resembled with the stolen property. Full stop. From perusal of the entire evidence of the prosecution, we find that none of the inmates of the family in whose house Dakati took place had come forward and stated that the above articles stolen from their house, nor they identified those articles in court. Full stop. It is further appears that the said articles were not produced in court. Full stop. Para. However, the learned trial court had given a finding that the articles recovered from the possession of appellants were put on test identification parade and the witnesses identified the same as their stolen property. Full stop. But surprisingly, the test identification chart of stolen articles not proved by any witness, including the officer who conducted the test identification parade. Full stop. Under the said circumstances, the aforesaid finding of the learned trial court is absolutely without any evidence. Full stop. Thus, we find that the part of the judgment of the court below is based on conjuncture and surmises. Full stop. Now coming to the identification of these appellants by PW1 to PW4, it is worth mentioning that all the witnesses claimed before PW5 that they identified the ducats while they were committing ducati. Full stop. It is an admitted position that the ducati was committed inside the house of PW1 and other persons of the village. Para. Learned counsel for the petitioner contended that the impugned order of allowing the election petition of respondent number 4 was based on three grounds. Full stop. The first main ground was that pro forma 4 relating to said election was not available. Full stop. His contention is that the said document relating to form 4 was not available because it was present with sealed ballot papers and was not called for perusal. Full stop. His submission was that second ground of passing impugned order was the alleged arithmetical error in counting of voters. In this regard, he has full stop. He has submitted that although there appears arithmetical error of one count in counting of votes, but this will not affect the result because in form 4 and form 6 relating to said elections, the total number of valid and invalid votes were specifically mentioned. Since form 4 is prepared on the basis of form 6 and form 7, therefore this arithmetical error can be rectified by calculation, and in fact no error was committed when result of said election was declared. Full stop. His further submission is that in spite of filing of written statement, the prescribed authority had found it technically erroneous and had not accepted its pleadings, although there was no error in said written statement, which is in accordance with law and procedure, and such pleading should not be discarded at the time of judgment. Full stop. On the basis of these contentions, learned counsel for the petitioner prayed for quashing of the impugned order of recounting of ballot papers. Full stop. Para. These submissions were refuted by Shri H. N. Singh, senior counsel for respondent number 4, who submitted that written statement of the petitioner was not discarded by the full stop